mechanisms of the United Nations. We're pleased to be hosted primarily first by Liechtenstein. We're having some feedback. Can we? That sounds better. Thank you. So the primary host here today is Liechtenstein, and we'll be hearing in a moment from the permanent representative of Liechtenstein to the United Nations in Geneva. But we also want to thank the co-hosts, the Kingdom of the Netherlands, Switzerland, Austria, Finland, Chile, and Sierra Leone. Let me at this point introduce Ambassador Frank Buchel. The recently arrived, I don't know how long ago it was, but relatively 4 weeks ago, at the beginning of the Human Rights Council session, as the permanent representative from Liechtenstein. And thank you so much for hosting, and the floor is yours.
Thank you very much, Ambassador Rapp, for giving me the opportunity to be with you today. Distinguished colleagues and friends, good to see so many of you here today. I would like to thank also the International Commission of Jurists, as well as the Institute of Ethics, Law and Armed Conflict at the University of Oxford, for organizing this important side event, and the co-sponsors for their support. Today's gathering gives us the opportunity to build on discussions we have initiated 2 years ago, now underpinned by the 2 excellent reports that were issued by the conveners. The question on how we can take and make the work of UN investigative mechanisms more efficient and effective, how to use synergies, and how to ensure the sustainability of their work have only become more pertinent in the past 2 years. Rarely since the creation of the United Nations have we faced a global situation where the devastating impacts of impunity for past crimes have fueled the emergence of a number of new conflicts, or the continuation of past conflicts where no sustainable transitional justice has taken place. We see this not only in relation to Russia's war of aggression in Ukraine, or in Sudan, in Myanmar, but also in the Middle East and in many other parts of the world. The United Nations has an important role to play when it comes to collecting and preserving evidence for serious human rights violations and investigating possible crimes under international law. It is in our interest that UN investigative mechanisms can work efficiently and effectively. In the light of enduring liquidity and budgetary constraints and the increase of the number of investigations as a result of the growing number of conflicts, it is important to have an open and transparent dialogue on how synergies between the mechanisms can be realized and whether new models should be looked at in order to ensure the effectiveness of the investigations. We are looking positively at the new Human Rights Inquiry Branch of the UNHRC as an important step to strengthen investigations, but also the collection and preservation of evidence and information. We stress in this respect the importance of hiring experts with suitable backgrounds for the tasks, as well as sufficient funding through the UN budget. We see the Human Rights Inquiry Branch complementary to the long-term goal of creating a single standing investigative mechanism based on the model of the Syria mechanism, which would be able to operate independently and with a broader mandate. I'm pleased to share a podium with such distinguished panelists that have not only a vast experience in this field of work, but probably also some answers to the questions related to how best address the needs for credible and effective UN investigations. And I'm looking forward to a fruitful debate. Thank you.
Thank you very much, Ambassador. First of all, UNOG requires me to announce that no photos are allowed during this event. We've got victims and survivors here as well. There will, however, be photos, but only of the head table by a photographer here from ICJ. In case you see someone taking it, that's why. Let me just introduce our discussion, first of all, by introducing myself. I'm Stephen Rapp. I was former United States Ambassador at Large for Global Criminal Justice under President Obama. And before that, I was an international prosecutor at the Rwanda and Sierra Leone courts, now a senior fellow at the U.S. Holocaust Center for the Prevention of Genocide, and also at the Oxford Institute for Ethics, Law, and Armed Conflict. This follows up on an event. It's been some time now, 2 years and 3 months, an event that we held here in May of 2022, when we announced the results of our Oxford study that involved field research and dealing with 160 individuals that are involved in current processes and also from civil society and from investigative and transitional justice authorities at the national level. And we had recommended the establishment of a standing investigative support mechanism or alternatively an investigative support division within the Office of High Commissioner to provide for human rights inquiries that have accountability mandates, something of the same kind of capacity that was provided very specifically to the Syria situation and the Myanmar situation by the creation of those independent mechanisms. Shortly thereafter, our colleagues at the International Commission of Jurists, who had conducted a consultative process supported by the Dutch and German government, recommended the establishment of a standing investigative mechanism. Thereafter, we engaged with the High Commissioner, the new High Commissioner, when he came on, Volker Turk, who was quite interested in this project and asked really for time and space to see how he might respond to that. And the specific answer, after continuing to consult with him, was the establishment on 18 June of this year, just about 3 months ago, of a human rights inquiry branch within the Office of the High Commissioner, which pulls together personnel that were previously working in field operations in the specific investigative support unit that had earlier been established, from the methodology section, from the rule of law section, and from some other parts of the office. Now headed on an acting basis by Beatrice Balbin, who had her incumbent position had been head of the Special Procedures Branch. And it has proposed, the High Commissioner's proposed to New York, to the budgetary processes of the Fifth Committee and the UN General Assembly, initially 4 new positions, including a D1 to be recruited to lead this branch, and 3 other experts, anticipates further requests for ex-budget support for the office. In terms of official announcements, and we'll hear from Alexander El-Jundi from the branch today, just read, and you may have seen this, it was publicly issued on the 18th of June, about the vision. The vision of the branch is a dedicated structure to undertake and support cutting-edge inquiry-related work. It will progressively add new skills, capacities, and technologies encompassing areas such as gender, child rights, victim and witness protection, communications, while strengthening our ability to start up mandates, provide specialist surge support, and undertake our own inquiries with dedicated personnel. It will also upgrade our capacities to maintain, research, and access physical and digital archives of current and past investigations, maintain data integrity, confidentiality, and compliance with legal requirements, while facilitating further analysis of archived material and in accordance with UN Secretariat frameworks, strengthen appropriate information sharing with accountability mechanisms. All of this important to the commissions of inquiry and fact-finding missions established by the Human Rights Council, of which I think there have been close to 38 since 2009, and often they have not had the capacities that are intended to be provided by this branch. Today, to answer questions and to hear your comments and suggestions, we have a number of expert speakers, including Alexander El-Jundi, who was head of the investigative support unit and now has moved into the new branch to head its section on investigative support. He formerly worked as a legal advisor in the Yugoslavia Tribunal and on many human rights inquiries. We have Marta Valinas, who will be joining us by video link from Venezuela, or excuse me, from Portugal. She's a career prosecutor from Portugal and, of course, chairman of the fact-finding mission for Venezuela. On my left here in the room, you see my good friend Mazen Darwish, who's the director of the Syria Center for Media Freedom, also president of Fédération Internationale des Droits de l'Homme, FEDH, and of course very active in extraterritorial prosecutions of crimes committed in Syria, particularly in France, but elsewhere as well, including the recent case against President Assad himself, his brother, and 2 officers of the SSRC, and of course has worked closely with the Syria mechanism. And then we have Santiago Canton, the Secretary General of the International Commission of Jurists, formerly Executive Secretary of the Inter-American Commission. And as I noted, ICJ led this consultative process and continues to lead consultative processes around the world, in which we're joining, where we've been to Nairobi to meet with civil society on this issue. We'll be soon to Bangkok, and then next year to Latin America. And then finally, my colleague in the Oxford Project, the deputy director of the Oxford Institute, and now a fellow at the Carnegie Endowment for International Peace in Washington, Federica D'Alessandro. So let's turn first to Alex and pose the question to him. You're now moved from from field operations to this new branch, and I'd like to ask you what's happening in the new branch, what activities, what's it able to do that hasn't been done before, and in terms of those that were in it, what's planned in terms of implementing the vision of the High Commissioner.
Many thanks, Ambassador Rapp, distinguished friends and colleagues. It really is an honor to join this discussion on the future directions for UN accountability mechanisms. UN accountability mechanisms really play a crucial role in uncovering violations of international human rights, humanitarian, and international criminal law. Currently, the Office of the High Commissioner provides operational support and facilitates numerous accountability processes for atrocities and gross human rights violations. This includes the provision of support to 12 current Human Rights Council mandated investigations on some of the most serious human rights emergencies in the world: Ukraine, Palestine, and Israel, Sudan by way of example. This support that we provide stems from startup, the development of concept of operations, budget, identification of possible experts, and the putting in place of a startup team from the newly created branch, while we run a recruitment process for Secretariat staff. This runs then right through to the wind down and the taking over the archives of the information evidence collected by the investigations. Just quickly to highlight that these investigations contribute to accountability in a number of ways. They issue public reports and engage in interactive dialogues at the Council and increasingly before the Third Committee of the General Assembly. In addition, they engage in domestic and international accountability processes, both judicial and non-judicial. And similarly, valuable information originates from the human rights monitoring, investigation, and reporting work undertaken by the High Commissioner under his global mandate. Just to give you an example of the contribution to accountability that one of the supported investigations has done, the Commission of Inquiry on Syria has so far cooperated directly with over 60 criminal investigations into war crimes and crimes against humanity committed in Syria since 2011, having received over 300 requests for assistance directly. In addition, several hundred concrete records, many testimonies from the Commission's holdings, were shared with the IIIM to support 84 additional investigations and prosecutions by 10 competent national jurisdictions. It also gathered information on several thousand alleged individual perpetrators, relying on over 10,000 individual testimonies gathered so far. Once Human Rights Council mandate investigations complete their work, the branch, on behalf of the High Commissioner, takes over and manages their archives. And one aspect of this role is responding to requests for information from domestic and international accountability processes in close consultation with the Office of Legal Affairs. Now, in terms of the branch, for the High Commissioner, support for accountability lies at the heart of his mandate, deploys vital preventive and deterrent effects against continuation of human rights violations throughout the world, and stands as a cornerstone of the human rights framework. His vision is for human rights to remain, for OHCHR to remain the global anchor in promoting accountability for victims and survivors, and in doing so, be sufficiently equipped to meet such demands. As Ambassador Rapp flagged, in order to achieve this, the Office has established a single, unified and dedicated structure, mandated to provide integrated, comprehensive backing to the full range of investigative work being undertaken. This structure is tasked with providing coordinated staffing, policy, thematic, legal, methodological, operational, administrative, technological, digital, and technical support to independent investigative bodies set up by the Council, as well as to OHCHR investigations and inquiries, along with a dedicated section to support the collection and analysis of information and evidence in accordance with the existing Secretariat framework for cooperation. Aside from enhancing OHCHR support towards ongoing investigations and the promotion of accountability, the Office aims to strengthen its own standby capacity in order to be able to deploy as soon as a situation of concern arises, with a view to collecting and preserving information and evidence. on potential violations of international human rights law, as applicable, as well as international humanitarian law, including in the digital space, before it may be degraded or lost. A recent example of this capacity has been in Bangladesh, where following an invitation by the interim government, the office deployed a small fact-finding team, with back support provided by the branch in Geneva to Bangladesh, where they are currently investigating and collecting and preserving information and evidence on human rights violations and abuses, which occurred in the summer process. And this team was on the ground just over 2 weeks after the receipt of the invitation by the interim government. The branch has three main components. Firstly, investigative support, which is a section that I manage. The second one is information systems and digital support. And the third one is judicial cooperation and analysis. The investigative support component aims to expand the overall standby capacities and ability to start up and surge several mandates or deploy in parallel and adequately resource substantive support functions that are critical to effective investigations. It aims to deliver greater uniformity and consistency of approaches and ensure that lessons learned and good practices consistently inform operations. It aims to enhance standard service support to investigations, to the onboarding of specialist expertise necessary for such investigations, including sexual and gender-based violence and gender experts, child rights experts, forensic pathology expertise, victim and witness protection, legal guidance and methodology, military expertise, and expertise in security sectors. Secondly, the digital support component provides a digital architecture and tools required for conducting a modern investigation, as well as for the analysis and preservation of digital information and evidence in line with international standards in a way that maximizes its use in future accountability processes. It is also tasked with the enhancement of a centralized archive for both physical and digital information and evidence for human rights investigations, ensuring a long-term home for such information and the ability to preserve information in line with international standards, continue as appropriate to analyze the substance of such investigations and handle requests for information and judicial cooperation with accountability mechanisms. The third component is a judicial cooperation analysis, which aims to firstly streamline engagement and strengthen partnerships with external actors working on supporting the accountability file, including international and domestic accountability processes, NGOs, law groups, and other civil society actors. Secondly, it aims to enhance the office's ability to continue to analyze information collected by past investigations and currently within the archive of the Office of the High Commissioner. In this way, ensuring that the archives are kept alive and active. Thanks very much.
Thank you very much, Alexander. Is Marta Valinas available on the video? Ms. Valinas?
Yes, I'm here. I'm here. I can hear you well.
Ms. Valinas?
Yes.
Marta, yes.
Yes.
We can't hear. We need to move up our volumes. Hello?
Hello.
Oh, now we can hear you. Okay. Thank you very, very much for joining us today. This is Stephen Rapp, and you're joining us in room 25, which you know well at the Palais des Nations. And we were talking about, the future direction for UN investigative mechanisms. Of course, you had the independent fact-finding mission for Venezuela. And we would like to ask you, because this all involves assisting mechanisms in their accountability mandate, or that portion of their mandate, how the Venezuela FFM has been able to contribute to accountability at the international, in international systems or national systems, and what more do you think you need from Geneva, from the Office of the High Commissioner, in order to achieve what you see necessary to accomplish your mandate and your mission?
Thank you so much, Ambassador Rapp. I hope you can hear me well now, and I hope you can see me as well. It's an honor to be here with you today to discuss this issue. At a point in time when gross human rights violations and international crimes increasingly affect multiple parts of our world, and when certain state and non-state actors act bluntly with an apparent expectation of impunity, and with disregard for fundamental values and calls to respect them, investigations into those violations are more needed than ever. Investigations that are robust, more efficient, and most of all, independent. Investigations that follow a solid methodology that may allow their results to effectively contribute to accountability. At the fact-finding mission on Venezuela, we have taken the accountability component of our mandate very seriously since day one. We have defined the scope of our investigations and adopted a methodology that placed at the center the investigation and analysis of responsibilities associated with the violations we were documenting, both institutional and individual responsibilities. We have, for example, in 2022, described at length the modus operandi of the state intelligence services, their structure, and most importantly, the involvement of key individuals, both higher up in the chain of command as well as direct perpetrators, their involvement in the commission of arbitrary detentions, torture and other forms of ill treatment, and sexual and gender-based violence. After a careful assessment of the risks involved and the interests of accountability and prevention, we named various of these individuals in our report, individuals who were at least put on alert. Last year, we dedicated part of our investigation to describing a new directorate that had been created within the National Bolivarian Police and showed how key individuals who had been involved in gross human rights violations in intelligence services, as well as in a police unit that had been dismantled by the government in response to international condemnation, were just recycled into this new directorate, and together with them, the same modus operandi used in the other institutions where they had previously served. This year, we confirmed what we had feared and documented their actual involvement in various arbitrary detentions in the pre- and post-electoral context. All of this information that we were able to collect and analyze provides a significant contribution to judicial processes of accountability, and we believe that this is one of the main tangible outcomes of our work. At the moment, important accountability efforts are underway for crimes against humanity committed in Venezuela, an ongoing investigation by the Office of the Prosecutor of the International Criminal Court, and 2 proceedings before the Argentinian courts under the principle of universal jurisdiction. We have received requests for information, and we consider this to be a priority for us. This is an effort that requires dedicated time and resources, but it is definitely worthwhile. For UN-mandated investigations to be able to have a real, significant, and timely contribution to accountability efforts, these investigations need to be provided with the necessary resources, timely as well. It is of no great use to have an ambitious mandate with only just over half of the resources that were deemed adequate and necessary to fulfill that mandate. It is also of no great use to us to have that half of or over half of the necessary resources, and at times have to wait months for staff to join what is a 1-year period of investigation. High staff turnover due to the temporary nature of contracts is an additional challenge. It is of utmost importance that the staffing of these mechanisms takes into account the different skills required for human rights monitoring versus investigation, which is what we do. We need a specific skill set in order to be able to conduct investigations in the framework of accountability-oriented mandates. Accountability-oriented investigations require a specific methodology and technical knowledge. It is also of utmost importance that we do not face unnecessary hurdles from outside the mission, including institutional, bureaucratic delays that are placed on processes of sharing information when requests for such information come to us from criminal jurisdictions, as I just mentioned. All of these are challenges that we have faced and continue to face to varying degrees throughout these past 5 years, which affect our capacity to fulfill our mandate in the depth or the time frame that we would like. Besides the resources that OHCHR is mandated to provide to our mission through the Council resolutions, we have also benefited from additional assistance through deployments by Justice Rapid Response. And this type of assistance has been crucial due to the specialized skill sets that characterize its roster. Shall the mandate of our mission be renewed, we hope to see positive steps in ensuring that our, as well as other investigative mechanisms, are strengthened and supported so that our work can contribute to the work of the Council and ultimately to the promotion of human rights and accountability. Thank you so much for your attention.
Thank you very much, Ms. Bolinas. Very, very helpful. Now we turn to my friend Mazen Darwish, who I mentioned earlier, has been active in these extraterritorial prosecutions for crimes committed in Syria, both by the regime and also by opposition or extremists. I know he's worked closely with the Syria IAM, which certainly I've seen has probably one of the better relationships that I've ever seen between UN bodies and civil societies. And I think has something like 98 relationship agreements with various civil society organizations, and then also with national prosecutors as well. And I think you probably signed one of the first of those agreements. So I'd like to ask you, what, from your experience, is needed, and what kind of things, what have you learned from your work with the mechanism in terms of what a branch or what capacity could be provided to mandates who are required, as was the Syria mechanism, to assist in accountability?
Yeah, thank you very much, Ambassador Raab. And yeah, we have long experience with the IIIM, but let me go before the creation of IIIM and before 2017, when they start work. Civil society in Syria start documenting the crimes from all parties since 2011, since the conflict start. But one of our questions, what we will do in this documentation? A lot of effort, a lot of funding for civil society and initiative in this regard, and a lot of victims who have their testimonies and their experience, a lot of de facto who's have huge knowledge about the structure and chain of command everywhere. And we don't know where we can go in this, especially that ICC, it's blocked for Syria. So for us from the beginning, we need address, we need a place we can put all of these efforts, all of this documentation, and all of this important evidence also. So this is maybe why we also advocate a lot in 2016 with Liechtenstein and Qatar to create this mechanism. For us, this is one of the guarantee that our work, our efforts, it will not gun. We knew that between 2011 and 2017, there is more than 60 initiatives and organizations who's working in documentation for several reasons, for the conflict, for the funding problem, all their work done. So this is maybe the most important. And even if now we believe that it's not easy to go to the ICC or to have a transitional justice in Syria, but minimum we knew that everything is solved. Otherwise, also, as Alex mentioned, the IIIM received more than 395 demands from jurisdiction, but this is also an example. Without this work, with cooperation with the civil society, I don't think that this is be possible from the beginning. So putting this effort together, better understanding, creating relation, also supporting civil society to move from human rights documentation to legal documentation. This is also very important. The feedback, as you mentioned, Ambassador Raab, yes, we maybe from the beginning we signed one of these MOU, but now we have even 3, and we moved to have and receive the feedback, which usually we don't have it in the civil society. It's maybe a lot of learning. We have it from working in human rights field, but now we start working in the court, demand from the court, from the different jurisdiction, and this is also a huge effort. But also, let me mention also for us as a victim, as a civil society, that how much important to feel that all of these efforts will not go away. We learn from the experience, especially in our region, that like what happened with the fact-finding mission in Yemen, in Libya, later in Iraq, that this could be, for political reason or financial reason, could be done. So there is no guarantee that we can fight impunity and fight extremism, because not only the work, it's regarding the war crime and the crime against humanity. Also, the cooperation with the IIM, with the other jurisdiction, led to put in custody several members and leaders from ISIS also. This has happened in Germany, this has happened in Netherlands, in Sweden, and we are very proud that this part from our cooperation. You mentioned the case in France about using the chemical weapons, also in Koblenz in Germany, now in UK, one of the newest complaint from the civil society. And now we go directly to the jurisdiction and ask them, IIM, they have information, they have evidence, so you can go directly to them. And for us also, it is more easy while we working with more than 13 jurisdictions to communicate directly with each of them in their language, in their demand. And this has also put a lot of heavy duty for the civil society. But it's more easy for us to send all of this documentation, information, evidence to one place and told them, here you can go. No need even for duplicate the effort. When we are talking about 395 demand and IIM answer 288, this means that we reduce the effort and the expensive in 88 investigation for the civil society and for also the local jurisdiction. And all of these, it's mean a lot, and it's led to very important practical steps, not only for Syria, but I believe this can be for the whole region, but also in many other countries also.
Thank you very much, Mazen. Very, very helpful. Let me turn now to Santiago Canton. This project, in particularly the recommendation for a standing investigative mechanism, has been a priority of the International Commission of Jurists, which you had, and now with this, we now have this initiative from the High Commissioner. What are you looking for this? What are the needs that this branch or whatever mechanism is established needs to? What needs should it be meeting, and how should that be accomplished?
Thank you, Ambassador Rapp, and particularly thank you for your leadership on this issue over the last few years and the collaboration we had with you and the ICJ. Let me also thank you, all the panelists that have accepted to participate here today. At the ICJ, at the International Commission of Jurists, we've been working over the last few years to explore what is needed to strengthen human rights and criminal investigation at the UN level so that victims can access remedies and reparations. As a result of that work, we developed recommendations of what a robust UN international investigative mechanism might look like, with standing capacity to investigate quickly when demanded by emerging situations and ensure sustainable measures to support justice processes over the long term. We welcome the Office of the High Commission of Human Rights efforts to consolidate its best practices and ensure they can be capitalized on and to address the continuing challenges and gaps in the existing infrastructure through the Inquiries branch. But let me mention now some of the critical principles that we believe are needed for this initiative to be successful. An investigation body of this nature should be independent or autonomous. And all the experience of international institutions reflect that need. It has to be independent or autonomous. While administratively, it would need to be within the UN system, operationally, it should have freedom to investigate within the confines of international law and best practice the crimes and actors within the context over which it has a mandate as sees fit, without the pressure of competing priorities, including the provision of technical assistance and other responsibilities. This is how bodies like the IIIM and IIMM are set up and have proven to be an effective model for contributing to justice. The investigations unit should also ensure it is, to the extent possible, immune from actual or perceived selectivity, granting it the legitimacy it needs to have impact in the short term and ensure it can effectively contribute to criminal justice processes in the longer term. We need to be careful that any special funds do not come with conditions that would tie the independence of an accountability mechanism. On the other hand, to be funded through the regular budget means it will be subject to budget freezes as the Office of the High Commissioner of Human Rights today is experiencing, replicating resource constraints that existing mechanisms already have. Along with operational independence, an independent budget drawn from the regular UN budget is one solution. And it should operate transparently so that it can remain accountable to mandate providers, victims, and affected communities. It should publicize its functions and, within security and confidentiality constraints, its activities so that relevant stakeholders understand how they can contribute to its work and strengthen and benefit from it. We should also ensure that this type of mechanism can address both classic human rights investigations to advance state responsibility and the gathering of evidence to ultimately bring individuals responsible for crimes under international law. These are both complementary and necessary objectives. Reporting functions should be insulated from work to support individual criminal accountability, to ensure one does not jeopardize the other by getting ahead of the evidence and predetermining outcomes. This is no doubt a continuing conversation, in which we are here to see how the UN investigations can reach these standards, and in which we can take positive steps to ensure victims are heard, truth is told, and justice obtained. Thank you.
Thank you very much, Santiago. Let me turn now to my colleague, Federica D'Alessandra. Federica, we led this project at Oxford that, as I noted earlier, recommended an independent mechanism, or alternatively, that this be done within the Office of the High Commissioner for Human Rights. And we now, of course, have the High Commissioner in the vision that we read, and as Alexander told us, that's attempting to do a lot of what we spoke about. But I want to ask you, as this is developed, what needs to be done and what is really required in order for it to meet the sort of requirements for accountability that we identified.
Thank you, Stephen. Good morning, all. It's a true pleasure and a privilege to be able to partake in this discussion and to see how many of the ideas that we put to the fore over the last few years have been taken on board, and we're continuing to discuss them, moving in the right direction. So I want to start by actually commending the High Commissioner for his initiative and his vision for the new Human Rights Inquiry Branch. Those in the audience who are already familiar with our work at Oxford will know that we have been calling for this type of reform around specifically respective of the modalities, but around centralizing a number of common investigative support functions for quite some time now, certainly consistently since the publication of our Anchor Accountability Report in 2022, which was the culmination of a long series of studies tracing tracing back actually over a decade on the challenges and opportunities ushered by what we call the accountability turn here in Geneva, and now to fill important accountability gaps. As that work is publicly available, we have limited time today. I won't enter into more details in terms of what our study found at the time, but I do want to take this opportunity to commend again the High Commissioner for his continued engagement with our findings and actually for acting on many of our recommendations. Let me say, however, that a key point we raise in the work remains, which is that regardless of the possibilities or even appetite for creating a permanent investigative mechanism, which we can discuss the length in this setting, and frankly, we believe certainly remains a crucial and quite possibly complementary proposal in many respects. But there can be no doubt that there also is a concurrent and unquestionable need to strengthen OHCHR's internal capacity in these areas. This is true whether we consider the ongoing needs of council-mandated inquiries, as we've heard in the observations offered by Commissioner Valinas, which continue to be strained by paucity of resources, timeline and budgeting issues which affect recruitment, deployment, standards and methodologies, reporting, and of course the renovation of their mandates, among many other challenges, or whether we consider ongoing and certainly future needs for standby capacity, as we heard, to promptly and more effectively respond to urgent situations, be it under the High Commissioner's own prerogative or at the request of interested states, as in the case in Bangladesh. The point is, once the infrastructure is there, it can be put to use to support a variety and a multiplicity of mandates. They all requires similar technical and investigative support functions. And of course, they raise different contextual reporting and even oversight questions that we need to continue taking into account and discussing. But they all have similar needs around, capacity and support of certain investigative functions. But I think what's also important to underscore is the fact that the same capacity and infrastructure can be put to the benefit of OHCHR's broader responsibilities and core mandate. The support functions that the High Commissioner is seeking to centralize under the new Human Rights Inquiry branch are not mutually exclusive or detrimental, for that matter, to its overall mission and mandate. Quite the contrary, they can be force multipliers that help the High Commissioner's office have more and better impact, achieve efficiencies across all domains of his work. And the same, by the way, is true for, when we think about transitional justice purposes well beyond accountability. Ultimately, and really we cannot stress this enough, no one but the affected communities have a right to decide for themselves what form of justice, transition, accountability is right for them. Criminal or otherwise, judicial accountability may not always be the answer. And equally, their own views about whether accountability should or not be part of the answer might vary over time, right? With generational change, even over decades. But the fact of the matter is that if information gathering, analysis, and preservation is not being approached correctly since the beginning, even if down the line the affected community wanted to pursue accountability, given the high standards this require, chances are that possibility might be precluded from them. So, we believe, and we've said it many times, that as an international community, our responsibility and in fact our duty to affected communities and to victims of serious human rights violations and international crimes is to ensure we can keep as many pathways as open for their decisions to be made, whatever these might be and however long it might take. And that's precisely also, by the way, the reason why we have been consistently calling for not just the building of the technical sort of infrastructure, but also the right expertise. We've heard, and I was very glad to hear, just into how much detail you entered in terms of the type of experts that you will be bringing into this branch. That cannot be stressed enough how important it is, because it will have ripple down effects, as we've discussed many times in our work and in our public discussions and closer discussions. But equally important, that's going to require all of you as states support, both financial and political, of course. I'm also particularly encouraged to hear about the High Commissioner's vision for the long-term needs around information analysis, security, live archive management, preservation, because that's really been a persistent need in the space. And actually, this might be where states' foresight into solid investment to shore up the technical infrastructure that is needed to do this might pay its greatest benefits over time. You know, there's a lot to say. Obviously, we have limited time, but in concluding my intervention, let me just reiterate one crucial aspect of all of this, which I think our colleague Mazen has already spoken to quite eloquently, which is, you know, there's a reason why we talk, my colleague and I, Ambassador Rapp and I, as well as many other colleagues, talk about, you know, an international justice ecosystem. And we cannot and must not forget that the engine, and in fact, the entire rationale of its existence is the civil society. And so, in addition to commending, of course, our commissioner's clarity and vision around the need to invest in what we have called sort of downstream relations with, you know, sort of the users of this information when it comes to judicial proceedings. So, you know, law enforcement, you know, judicial authorities, as we understand is envisioned in the third section of the branch that has been discussed, it is equally, if not more, important to focus and cultivate what we call upstream relations with victims, affected communities, with civil society documenters. And this cannot happen exclusively once an investigation into a given context, a country situation has been, you know, has become active. This is something that needs to be continuous and ongoing, both because it can help to build trust, it can help civil society groups themselves improve their own documentation practices and understand how and where to focus their resources, but also, and especially importantly, because there is an enormous amount of substantive, you know, contextual, regional expertise, and especially lessons learned, or that should have been learned and needs to still be incorporated and assimilated from the experience of countless civil society groups that have been engaging with UN inquiry mandates over the last decades or so. And these cannot be overlooked and ought to be taken into account and incorporated into the very design of the branch, precisely to prevent past challenges from sort of persisting in the future. As we commend the High Commissioner for this initiative and certainly vow to ourselves continue to support this process and endeavor, we equally invite and encourage more civil society groups to join into broader consultations and to engage with the High Commissioner's vision and ideas moving forward, certainly, but already at this stage. I think I'll leave it at that for now, but thank you so much. And it's been a pleasure.
Well, thank you very much, Federica, and for bringing up the ecosystem model, because as we sit here in Geneva, we have to recognize Geneva is just part of that. And to a large extent, it's a matter of ensuring the flow and the accuracy of information that comes from those that are on the ground to those that then have need for it in official processes. So we've got about 10 minutes. Unfortunately, we have a very hard stop at 2 o'clock because 3 of us have a meeting at Pele Wilson at 2:30. But let's go ahead and hear from your questions, and perhaps we could take 3 to 5 of them and then try to make very pithy answers and finish in about 10 minutes. So let's go ahead. Questions. If you're representing a state here, turn your tent on its side. Obviously, not everyone is, and so raise your hands as well. But let me turn to you. Yes, from the United Kingdom. Royaume-Uni.
Brilliant. Thank you very much. And my name's Gemma. I'm a Blavatnik School alum, so it's good to see you both here today. It's really helpful to understand more about the work of the Investigations Support Unit in the Inquiry Branch. And of course, you know, we see the importance of accountability, especially in Myanmar, in Syria, and in Sudan now. My question is kind of with this increased capability inside OHCHR, how do you continue to ensure approaches are tailored to different contexts, whether that is in terms of language, in the chain of command within different contexts, as well as the security situation for victims and those providing testimony? Thank you.
Thank you very much. Other questions? See any other? Let me, then while you think of questions, I'll turn to Alexander to answer that one, if you would.
Thanks very much. In terms of different contexts, I mean, each monitoring or documentation or investigation is tailored to the specific country in question, whether the office has a presence there or not. You know, but for example, Bangladesh is you know, again, the example we're looking at there, where we had a scoping visit, which went and met with civil society, with the government, with the students, bringing in, you know, language expertise, cultural expertise, and adapting it, as well as the investigation strategy and the information collection strategy. It's something we're, you know, very, very used to and very adapt to in all the countries we're working at. But, you know, I mean, I think you raised an important point there, obviously, that, you know, one size doesn't fit all. Everything is, each context is different, and we apply, you know, the frameworks we apply are also different, whether we apply exclusively international human rights law or we also apply IHL. This is all in the planning phase and the deployment phase taken into consideration.
Stephen, can I?
Yes, please, go ahead, Frederica.
Thank you so much for raising that extremely important question. So this is our view, obviously, and you know, my role here is in part to speak to, you know, how, you know, we things should be and move towards, you know, there's no doubt that there's both a need to increase the capacity for certain functions or common to all investigations, as it is true that, as Alex was just saying, each context is different, so there will be a need to bring in additional expertise that is tailored to that specific situation. We're in agreement with that. And the issue, I guess, there becomes on the basis of some of the research that we've done in the past, and I don't know that that has been addressed. You know, you can have rosters, right, where fundamentally, if you need to deploy fast, you need to be able to bring in those type of experts right away. And right now, there is a big gap in, even where you do have rosters of experts that have been pre-cleared, oftentimes it takes far too long for them to be brought on board for these type of investigations that are urgent. So even though you have standby capacity for certain functions, you know, you can't get all of the expertise in place in time for these type of investigations to be deployed promptly. And I think that that might actually require some rethinking of, you know, sort of UN hiring rules. But that's sort of an invitation and exhortation that we've certainly been making, and we continue to make to states, because it is an issue, and you've correct to flag it.
Any other questions? Otherwise, we can hear sort of final comments. Did you want to add something, Maza?
Yes, there is no question. Thank you. Also, just regarding your question, it's the majority of this conflict, it's linked to each other. By example, if I go to the MENA, now I can't separate the situation in Syria from Turkey, Lebanon, Israel, Palestine, Jordan. So I think it's also give an example how this body and collect effort can give also more understanding and working together. It's more effective if we want to have for each of these country investigation unit or expert to have one overlook about some of these crime in Syria. You can't separate it from all. So if it's all work together, maybe it's also will save how many experts we need to understand each conflict. Thank you.
And yes, question in the back.
Thank you very much, Ambassador, and a big thanks to the organizers and all the, I think, the tireless efforts that have been put into this also by academia and civil society. We wouldn't be here where we are without you. establishing a standing international mechanism, if such a thing were to happen at one point, I think would be in many ways the triumph of the law over politics, because the way it would be set up would mean that it would need to be shielded and guarded from political influence. Now, we have a number of mandates here at the Human Rights Council that I personally believe should be shielded from politics. Some are not. Some are ended by states who have a lot of influence and to push enough voting members of the Human Rights Council to finish a mandate. I think that is a bit of a Damocles sword that hangs over every Human Rights Council mandated investigation, and it's something that diplomats, like half of the room is filled with, have to tangle with at every Human Rights Council session. Would you have ideas about how to better to defend against the accusations of selectivity or politicization, which come for every mechanism, and we know that they are entirely translucent and they don't have any ground to stand on, but they still carry weight with some of the voting members of the Human Rights Council? Thanks.
I don't know if we have other comments, if I can just comment to that, because it's been a subject of discussion everywhere we go, and how to immunize from politics. And of course, recognize that even as we talk about the creation of mechanisms, if a mechanism were to be created, a standing one, and it were to gain a case-building kind of mandate, it would really probably fundamentally require a vote of states by the General Assembly or by the Human Rights Council in order to give it that mandate. There have been proposals for how to immunize it to a point, such as having a sort of a group of experts who would be surveying situations, who might then say this particular situation really requires such a mechanism or such a mandate. And that might then have a sort of a priority, might have a place on the agenda in any case, that it wouldn't be possible to sweep that one under the rug, and states would be confronted with the decision whether to do it or not. Also, at the end of mandates, and obviously you're referring to things like the ICRI mandate for the Tigray and Ethiopia, or we've had the end of the Yemen mandate, we've had the Libya mandate end 3 times, et cetera, and we've got challenges with some of the current mandates, and even while conflicts and atrocities continue. Do keep in mind that one of the things that the branch is talking about doing is a much better job of then responding to requests from the commissions that have already completed their work, that have gathered great information, and presently lots of times that stuff gets boxed away. There really isn't a staff to access it or to know where to find it. There are always challenges about going back and talking to a witness and getting consent and dealing with a security situation where there really isn't a capacity to do that. And I think one of the more exciting aspects of this proposal is this sort of third section, which is this cooperation division, which really focuses to a large extent on the post-mandate situation, where bodies have had the courage to create a mandate and work has been done. We don't want that lost. And we want kind of an analytical ability when a country asks a question because a suspect who is involved in those crimes has turned up, that will actually look carefully at that material, analyze what may be relevant, and respond in a flexible, sort of customer-friendly way to it, as opposed to the usual UN way, which is 3 years to get an answer, and then the answer is usually no. So I do think that this will help, in any case, provide for greater neutrality and meet some of these needs. But the crucial question will be now, of course, with this mandate, with this branch, is whether it has the resources to meet the requirements, the vision that's been outlined by the High Commissioner. As yet, we don't even have approval of the 4 positions in New York. And then obviously what's there, they've described to me as only about 20% of what they eventually envision to be constructed. And even that would probably be much smaller than either the Syria or the Myanmar mechanism. So it'll be limited what it can do at the end of the day. But and then we'll have to deal with these sort of questions of how investigations might be authorized, or at least brought to the front of the agenda in places where the politics are suppressing that sort of interest in the uniform application of human rights and international law.
Stephen, just 30 seconds because we're out of time, but yeah, I wanted to finger in this one. So he's spoken about, thank you for the question, he's spoken to the, I know we're out of time, the global mechanism piece of it. But, equally on the High Commissioner's inquiry branch, part of what has opened the space for that politically motivated criticism in the past has been that, frankly, and I don't mean to be overly critical of past work, but there has been some inconsistency, right, in standards that have been adopted, methodologies that have been adopted, but also in the type of evidence that we bring, right, to substantiate that. And I think that that's where investing in, sort of standardizing all of that and improving both standards and type of evidence that we bring to bear to evidence it's crucial. So thank you so much.
Well, thank you all for your interest and participation, and have a good day. Bye-bye.